from Arnold and Porter.
Good morning, everyone. This is Seller Beware, Avoiding the Pitfalls of Selling to California Consumers. And this is the second of two sessions, which we've titled The Grab Bag of Pitfalls. This will be something of a speed round, a tour through some of the more treacherous parts of California law for those who make or sell products that are offered for sale in California. For today's webinar, the lines have been muted, but if you need assistance during the conference, press the star key and then 0 on your phone, and a conference coordinator will be there to assist you. I have sent out a chat to everyone who's on the line now. Please use the chat feature tool within WebEx to ask questions throughout the program. We might not be able to get through all the questions, we just have an hour today, but don't hesitate to contact one of us directly following the event. We'd be happy to follow up with you as well. You can send your chat questions, we'll collect them and probably address them at the end of the session. This event is being recorded and it will be posted on the Arnold and Porter website where it will be available to the public. For your convenience, shortly after the program, we will send a link with a short evaluation and the presentation materials to each of you. Those of you, I believe, in New York and New Jersey will also receive a quiz, which is a required part of your continuing legal education requirements. So today's program is looking at some of the ways in which it is difficult to do business in California. We collected these from questions and issues that all of our clients have encountered over many years. We have 4 presenters today, so the presenters are in order: Kelly Welchens, Angel Garganta, myself, and Rhonda Stewart Goldstein. We're going to begin with Kelly, who is broadcasting from our Los Angeles office on the Made in USA claims. Here's the agenda displayed right now, and then Kelly will begin on Made in the USA. Kelly?
Thanks, Trent. Now, in California, Made in the USA claims are governed by Business and Professions Code, Section 17533.7. The statute is pretty straightforward. It says that any made in the USA, made in America, and similar words can't be used on a product or its container when any article, unit, or part of the product has been entirely or substantially made, manufactured, or produced outside the United States. Now, in California, the courts have taken a very strict construction of this statute. We've listed an example from Kwikset up on the webinar, and in Kwikset, the manufacturer made lock sets, and these lock sets were assembled from all domestic components except for just a few pins and screws that were made in Taiwan. These lock sets couldn't be labeled Made in the USA without violating the statute. Now, this is in conflict, California's law is in conflict with the FTC standard. And the FTC standard is not lenient by any means, but for an unqualified Made in the USA representation, the FTC allows for virtually all of the product to be made in the United States. And under the FTC standard, a label Made in the USA can be used if there is no or negligible foreign content. The FTC also has a qualified representation, and that's appropriate for products that include United States content and processing, but just not enough to make that unqualified claim. For a qualified claim, the product should still have a significant amount of U.S. content and processing. And the difference between the FTC and the California guidelines hasn't gone unnoticed in California. Just last year, the California Assembly passed a bill to try to amend the California statutes to conform to the FTC standards with respect to Made in the USA. However, that bill was defeated in the California Senate Judiciary Committee following significant opposition from consumer groups. So what's a seller to do if they sell things in California? On the next slide, we talk about compliance issues. If any of your products may touch California, and really for most national retailers, this is virtually guaranteed, you want to make any Made in the USA claim with extreme care. We suggest possibly trying an alternate claim, something that's closer to a qualified claim under the FTC guidelines. We've listed some up on the screen: Made in the USA of primarily domestic components, Made in the USA partially assembled in whatever foreign country it's assembled in, or assembled in the USA from primarily domestic components. This gives you protection, but allows you to still make the Made in the USA claim. And really, you should check with your marketing people and ask them if the Made in the USA claim really matters. And really ask the marketing people and ask them how much that claim matters. Because if it doesn't matter, or the influence of the Made in the USA claim is negligible, you should consider not making the claim in California because it's probably not worth the potential liability to make an unqualified claim. Now, on the next slide, we talk about what to do if you do get sued. There are a few potential arguments in defending against a Made in the USA lawsuit. And this is recognizing that the case law in the area is not particularly robust in California. There is an argument that you could make that there is no standing to sue. Under this argument, a plaintiff may simply fail to allege standing or may be unable to establish it. However, standing has gotten a little bit easier for plaintiffs to meet under the unfair competition law for product misrepresentation cases. So even if there is standing to sue, because in California, the monetary relief available is restitution, you can argue that there is no monetary relief available. Restitution is the difference in value between what the plaintiff gave the defendant and what the plaintiff received. And plaintiffs in this case would have to quantify the amount of the purchase price attributable to a Made in the USA representation. This has been difficult for plaintiffs to do as to date. And finally, these claims are often brought as class actions. Depending on the allegations of the complaint, there are often a whole host of issues to target that would make individual issues predominate over common issues. One such issue, again, is listed on our slide, and it's whether and by how much a Made in the USA representation actually influenced each individual consumer's purchasing decision. So the main things to remember about Made in the USA is that California's rule is different from the rule of the FTC, and it's more strictly interpreted. So if your products might touch California, consider first whether you need to make the claim, and if you do make it with extreme care. And at this point, I'll now turn the presentation over to Arnold to discuss slack fill.
Thanks, Kelly. I'm going to discuss a couple of California statutes that regulate what is generically referred to as slack fill. And slack fill is generally the difference between actual container capacity and the product volume inside the container. The idea of the slack fill laws, and the FTC has some slack fill rules as well, but as you'll see in California, everything's different, and the DAs in California have a lot of enthusiasm for enforcing these laws and extracting significant settlements from companies. The idea is that containers shall not be made, formed, or filled as to be misleading. And the two statutes that govern for general products, it's Business and Professions Code 12606, and for food containers, it's 12606.2. There have been some amendments, and in fact, an amendment was recently passed in the California Senate that we'll talk about. But the DAs continue to be very zealous in their investigation and prosecution of so-called slack fill violations, sometimes beyond actually the letter of the statute, as we will show you. So again, slack fill is the difference between the actual container capacity and the product volume in the container. When is the law violated? Well, the DAs take the position that it's violated whenever containers have false bottoms, sidewalls, or lids, or when the amount in the container is less than the capacity of the container. In fact, what the statute says is that it's only non-functional slack fill that's a violation. That is slack fill that doesn't fit into any of a number of listed safe harbors. So what are the safe harbors? And this takes a little bit to go through because there are a number of them. The two statutes have 6 of them in common, and then there's an additional one for food, which is packaging that plays a special function, such as the packaging itself has a role in the preparation of the food product or the consumption of the food product. The first one seems pretty straightforward, protection of the contents. And Arguably, you could say, for example, when you have a package of potato chips and you put them in a bag that's pumped full of air, well, part of the reason it's pumped full of air and it's not filled to the entire capacity of the bag is to protect the contents. Requirements of the machines, that means the machinery that manufactures the particular packaging can only fill to a certain amount. And that's one that's very hard to convince the DAs of, because they always argue you can recalibrate the machines or get other machines. Of course, that's not what the statute provides, but that's what they maintain. Unavoidable product settling. A lot of candy containers, for example, product will settle in shipping. But again, you want to test it so that when it settles, it doesn't settle so much that your package is only half full. Space for mandatory labeling, FDA, nutritional content panels, and other required labeling. The container itself has value. That means this is a unique souvenir type container or some sort of ceramic jar or something like that kind of thing. Inability to increase the level or fill or reduce the size of the package. And that's really an abbreviation because there's a lot of stuff that goes into this. Part of it is to accommodate labeling, discourage pilfering, facilitate handling, accommodate tamper-resistant devices. All of that falls into that exception, and it's enumerated in the statute. The reasonable relationship exception refers to a reasonable relationship between the packaging and the contents, and that requires that the contents somehow be visible on the exterior of the packaging. Representation of actual size, it means of the product on the outside of the package, and the key here is that it be a clear and conspicuous representation. Actually needs to state on the outside actual size clearly and conspicuously with a representation, a picture of the content, let's say a bottle inside a box. Now the DAs, despite that, have pushed very hard on this one. Even when it's represented, they'll say, well, that's not clear and conspicuous enough. Necessary space for mixing, that sort of speaks for itself. When you have liquids or powders, you need to mix prior to use. Delivery device, some sort of a dosing device in the product, and a lot of medicines and cosmetics have that. A component kit, so the product is split into pieces, and you have it packaged in such a way that it doesn't fill the whole box. Tester or display units means that the product is visible as a display unit outside of the box, or as a tester unit at the point of sale. Holiday and gift packages, again, if special fancy packaging, as long as the consumer can determine the size of the product at the point of sale. Free gifts or samples can not be completely filled as long as it's disclosed on the interior packaging. And finally, hardware and software is exempt if its function is disclosed on the exterior of the packaging. As I said, despite these safe harbors, the DAs pursue these actions very aggressively. It generally takes the form of a letter to the company from the DA saying, our weights and measures people have investigated your product and they found it slack-filled, and get in touch with us to settle the case, or else we're going to sue you in 30 days. And they've been very active. These are just some of the examples. These don't seem like huge settlements, but remember, these are for individual products. And you really have to be careful, because one of the things they can do, the maximum penalty if you violate the statute, is they can enjoin the sales of your product or seek an injunction against selling your product in California. There is a current revision to the law that passed the California Senate, which attempts to clarify what slack fill means. In other words, that it is the empty space in a package filled to substantially less than its capacity for reasons other than the enumerated safe harbors we've gone through. The intent of it is to reestablish that the mere existence of slack fill isn't enough to violate the law. And furthermore, it says it's declaratory only, which is to try to invalidate any pre-amendment interpretations by the DAs and the plaintiffs bar. But even if this is enacted, and it hasn't yet, it's in committee in the Assembly, and the governor hasn't signed it, slack fill allegations and claims, especially by DAs, are likely to continue in California. So what do you do to avoid this pitfall? You fill containers as much as practically possible. Alternatively and conjunctively, you design packaging to try to meet the safe harbors. You maintain documentation that shows a lack of fraudulent or deceptive purpose in the design, although again, that is not, in the DA's view, an element of the claim. And by the way, what you really don't want is documents that say, oh, we need to have the packaging X size to keep our shelf space. That is viewed, and perhaps so, rightfully, as an admission of liability, as an admission of fraudulent intent. Keeping shelf space means selling goods by having slack fill packaging. Make the contents visible when possible. Consider fill lines or representations of actual size on the packaging. Avoid, where possible, hidden compartments or unnecessary packaging that consumers can't see. And finally, track complaints to try to spot problems as early as you can. And now I'm going to turn it over to Trent, who's going to talk about human trafficking.
Hi. So obviously human trafficking is illegal in California, as it is in every other state in the nation, thank goodness. But California has been taking special steps with respect to human trafficking issues, primarily related to the supply chain, but also related to people who are indentured, essentially, oftentimes for the cost of their transit to the U.S. And then brought to California, which of course it borders both Mexico and therefore Latin America, as well as being a major port of entry from Asia. There has been a lot of activity in California from activist groups along the lines of human trafficking. They have sought very substantive and actually quite onerous requirements on companies that do business in California. So far, what they have been successful with, though, are 2 disclosure statutes. And I want to talk about those because these have often not received enough notice from even very large, sophisticated companies. The first of these is the California Transparency in Supply Chains Act. This law requires a website disclosure regarding a business's efforts to eliminate human trafficking and slavery from their supply chains, meaning goods that are made outside of the U.S., that are brought into the U.S., are they being made in ways that really not only violate general labor standards in those countries or in the U.S., but might even be considered to violate human trafficking and slavery laws. The law applies to probably a smaller number of companies than was the original intent of the activists. It definitely applies if your company has more than $100 million in worldwide gross receipts. That's not just from California, but over $100 million all around the world. And if you do business in California, there's a very low threshold for what it means to do business in California, and you may as well assume it's similar to can you be sued in California. If your goods end up here, even if it wasn't your specific intent to have them sold in California, you would meet that criterion. But a very important issue is that whether you are a retail seller or a manufacturer is determined by the SIC code, the Standard Industrial Classification Code, that your accountants put on your California tax returns. That number heretofore, I believe, has never had any consequence. It is used for preparing reports and probably for university researchers to review tax data on an aggregated basis. But here, if the SIC code has traditionally fallen within a category of retail or manufacturing, and you have worldwide gross receipts over $100 million, you're covered by this law. Now, many companies have chosen to comply whether they're covered or not. This law was effective January a year ago, and mainly because what you're required to do is relatively low in terms of what you actually have to put on your website. You do not have to take any steps at all to address human trafficking in your supply chain. Instead, you just have to disclose what it is you're doing or not doing on 4 basic categories. We have a packet of materials that describes this in greater detail, and in fact, it's sort of a starter kit for companies that would like to do something to set up a supply chain monitoring approach, just at kind of a minimal level of training and ways to spot these issues in your supply chain. If you're interested in that, let us know afterwards. There's not been any enforcement of the Transparency in Supply Chains Act, but we are anticipating it before too long. There's a list now that the California Attorney General has of the companies that were supposed to be complying with that. I suspect there's a summer intern in Sacramento whose job it is to look at the websites of all those companies and see if they can find these disclosures. And if you did not, you can expect to be receiving a letter sometime this fall from the Attorney General asking you why you haven't, and possibly press conferences in an effort to get people to better comply. The second of the 2 disclosure laws related to human trafficking in California applies to a very small number of businesses who actually have locations here in California. And it requires them to post a special notice, which I've given you a copy of here, within their businesses near the public interest in a conspicuous place. It has to be in English and Spanish. Depending on the county where the business is located, there may be other languages like Chinese or Vietnamese that also apply. And the idea is that these are locations where people who are otherwise escaping detection or maybe not fully integrated into society may nevertheless be found or may find themselves like bars and truck stops, massage parlors, etc. So the law requires that this sign be posted, and there are penalties for offenses. Again, I'm not aware of any widespread enforcement of this. There have been some folks who've been notified that they need to be putting the sign up. The law was effective just a couple of months ago, but another important thing that could trip you up. So considerations for businesses in this area. The primary thing is to realize this is a very hot topic in California. It's a hot topic around the country, but in California it's gotten traction, and laws have been passed to deal with this. Although there has not been enforcement here, this is a real focus of consumer and human rights organizations. It's a public relations issue. If your company is not already thinking about corporate social responsibility and these kinds of issues, it's a very important thing to give some thought to how you might address issues and how you might ensure that you don't have a problem. At the moment, they tend not to be legal issues, but more PR issues. We think they could turn into false advertising issues. For instance, if your company is making very specific disclosures that turn out not to be accurate, this can be a problem. Nike, for instance, had a major issue with this many years ago, and it was determined in essence that the First Amendment did not protect them. There are other efforts, of course. The SEC has rules about disclosing the use of conflict minerals like blood diamonds, but there's a whole variety of minerals that are used, for instance, in electronics. Your company's use of those needs to be disclosed now to the Securities and Exchange Commission. So this is a hot topic and something really to get ahead of. Then I also wanted to talk now about, this is a real grab bag of various product requirements, miscellaneous requirements, and there's really 3 sort of areas that I wanted to cover, and a 4th that requires thinking about what's happening in the future. The first of these is the CARB VOC regulations, and looking ahead here, to reduce smog, many years ago, the California Air Resources Board set up a regime that sets limits on the volatile organic compound content of consumer products sold in California. These are things like alcohols, things that you often can see or smell, but they may not be detectable with the human senses, that come off of products and go up into the atmosphere and help to contribute to smog. These laws apply to basically everybody who sells goods in California, whether you're a retailer, manufacturer, whatever. Other states and in fact US EPA have similar requirements, but as in many things, California is the one that enforces these aggressively. In addition, California has requirements that cover even more products than these other regimes. There are over 25,000 products that are covered in 165 categories. These are very common products, and this is a law that trips people up regularly because you wouldn't stop to think that, in fact, your product may be covered by this law. Different levels of VOCs are permitted in different categories of products. So categorizing your product correctly is very, very important. A good example is there are different levels that apply to underarm deodorant versus body spray. Although the two products have very similar purposes, the idea is one would be used in greater quantities and therefore its VOC content ought to be lower. The way this works is that CARB goes out and shops for all these products. They look online, they look at the internet, they love the 99-cent stores and these sorts of places. And they send a letter to the manufacturer of the product, sometimes to the retailer, but more frequently to the manufacturer. And there's a negotiation. Almost all of these cases settle on some terms or others. The penalties can be very, very large. They are usually set based on CARB's estimate of the quantity of excess VOC, measured in tons, that came off of your products in California within the statute of limitations period. And then because we have an emissions trading market in California, CARB knows how much it would cost you to purchase the right to emit that level of VOCs into the California atmosphere. And they want to make sure that you don't have an incentive to cheat rather than purchase that. So the penalties are often set somewhat higher than what it would cost you on the open market. You see here, most of these cases settle in the mid-five figures. There are definitely some six-figure settlements, and CARB just has a program that's self-supporting because they generate plenty in penalties to cover what it costs them to go forward with the program. Another statute, and this one has been around since 1991, is the rigid plastic packaging container law in California. This is a law, though, that just changed in January to cover a much larger number of products. So the agency that enforces it, which is now called CalRecycle, is out trying to get manufacturers to register more and more of them. If your product is on the shelf in California and they identify it and don't find a registration on file, you'll be getting a letter from them saying you need to register. What this law does is it tries to control plastic packaging that might end up in a landfill in California, which is hard to compress in the landfill and, of course, does not break down over the years that it sits in the landfill. It covers packages that are from 8 ounces to 5 gallons and any product sold in California except for most FDA-regulated products, and so that would include foods and cosmetics, dietary supplements. It does not cover pesticides. It does not cover hazardous materials. So cleaning products are definitely covered. And a very important part of the law now, what really has changed is that it now covers blister packs. What that means is previously you see here all the bottles, spray bottles, etc. Clearly the law covers these types of containers for liquids. But it's not necessary that the product be a liquid to be covered. So dog food that comes in a plastic jug would be covered. But more importantly, the law now covers blister packs if the plastic is capable of at least one closure, including the single closure occurring during the manufacturing process. it is covered by this law. And so if your blister pack is larger than 8 ounces, it's covered by this law. How does it work? Manufacturers have to register in advance. Annually, the agency will select a few of the manufacturers to certify their compliance. And they usually give you a year's notice before you have to do that. It's a very soft enforcement regime. They mostly want people to comply with the law, and at this point are not out there regularly seeking penalties. But what's it mean to comply? Well, there's several ways to say that I'm compliant with this law. You're perfectly permitted to have a container that meets the criteria I've talked about before, but it has to be 25% post-consumer material, in other words, recycled material in some way, or you have to be able to show that you have reduced the amount of plastic used in it by either reducing the container weight by at least 10%, concentrating the product, so like laundry detergent, for instance, has to be concentrated by at least 10%. Or you can do a combination of these two things. Another approach as well is if you've already done these things before they come to you, you can say, hey, I've already done this and my product is already concentrated below what sort of is the industry standard among competitors and that sort of thing. And so they're happy to have a conversation with you about that. You can also say that if it's reused at least 5 times and you really have data that show that consumers are reusing it that way, then you're deemed to be compliant with it. Or if you can show that you have a 45% recycling rate for the RPPCs in your system. In essence, this is actually the type of product that ends up, there's a whole market for recycling this particular product, that sort of thing. And then finally, there's an alternative program which says that if the entire company that has registered has also consumes post-consumer material that's generated in California, in other words, you're part of the recycling stream, and across your product line of RPPCs that equals or exceeds 25% post-consumer material, then you're also deemed to be compliant with the law, even if a particular closure is not compliant with the law. There's some exemptions for the floral industry, et cetera, these kinds of things. But, for instance, a food product like bottled water would not be covered by the RPPC law in California. But blister packs are the new news here and something very important to keep in mind. The next in our grab bag is the California Energy Commission efficiency regulations. These are similar to federal efficiency requirements, but they cover a lot more products. Ever since the oil crisis, the OPEC embargo in early 1970s, the U.S. has had standards for major appliances, refrigerators, washing machines, etc. And these are federal requirements. In California, there are more stringent requirements, and they cover more products. There are proposals to expand these to cover a bunch of electronic products as well as plumbing products like faucets and toilets and shower heads and that sort of thing. Retailers can also be liable, not just manufacturers. Typically, they look to the retailer first, but there are times when a product is made overseas and it's easier. Typically they look at the manufacturer first. There are times when a product's made overseas and it's easier for them to go after the retailer. A very important part of this is that the light bulb requirements in California are very strict. A CFL, a compact fluorescent lamp adapter, like the one displayed here, is illegal to sell in California. That means that if a lamp is designed to only hold a CFL that has those 2 pins in it rather than one you screw into it, you can't bypass that by buying one of these adapters and putting it in there. So we're legalizing marijuana, but banning these types of little plastic adapters in California. That's our public policy in the state. Lamps have to be fitted with these bases if they're sold in California, these special GU24 bases. or they have to include a CFL or an LED light bulb with the sale of the product itself. Now, this will apply to very few of you, but it's important to keep in mind because sometimes these are promotional products. Sometimes they end up with your name on them for some licensing reason. Sometimes it's something that you hand out. So it's important to follow this. And halogen lamps are under special scrutiny. There's some special reporting for halogen lamps now, and the prediction is that they're likely to ultimately be banned in California. And then finally, if this is not enough, here is a coming attraction, which is green chemistry in California. Green chemistry is a term that refers to making products with fewer hazardous chemicals or chemicals that are even thought to be hazardous. And California has a major initiative underway that dates from the Schwarzenegger administration. The regulations are incredibly expansive and will cover virtually every product that is sold in California. Again, there is an exemption in the law for drugs and for food products, but notably it does not cover personal care, cosmetic products. DTSC has a video that shows what they've been doing, and let me see if I can play it here.
I feel like I need a PhD to understand this.
Have you ever asked yourself, are these chemicals in these products necessary? Is there a safer alternative? DTSC is asking that very question to manufacturers and industry. The Department of Toxic Substances Control's Safer Consumer Product Regulations seeks to protect the environment and consumers by working with industry to find safer alternatives to harmful chemicals used in everyday products. It's part of our commitment to protect the environment and you, the consumer.
Maybe there's something greener on the next aisle.
So I think we may have a bandwidth issue there in displaying it, but at least it gives you a sense of what they're doing to raise the consciousness of people on this issue, and particularly for companies that sell products in California. There is a final package of regulations. These have been under review for a couple of years in Sacramento. Countless hours have been spent debating these issues. The administration, the Jerry Brown administration, is now reviewing this package, and we really expect that before the end of the year there will be regulations that are implemented in California about green chemistry. Now, the goal of the legislation was to reduce the one-off bills that kept appearing in Sacramento to ban a particular chemical in a particular type of product. And legislators found it impossible to vote against a bill that when you say, how would you like to ban bisphenol A in baby bottles? They may know nothing about bisphenol A, but this sure sounds like a good idea. And it's perilous for them to vote against it. In addition, the industry said, this is a really dumb way to make policy on chemicals. And as a result, the idea was, let's hand it to an agency of state government to review all these things and to regulate in this area. What they've done, because there was a set of engineers at the agency that regulates hazardous waste who were charged with this task, they approached it from an engineering mindset and said, let's look at every chemical that there might be an issue with. There's about 1,200 of those. Let's look at every product in which those chemicals might be found. And then let's select some things that we call priority products that we're going to focus on first, and chemicals of concern. And so if once we've identified the priority products and chemicals of concern, i.e. we're trying to reduce exposures here, then we're going to start looking at possible regulation of those types of products. First up on the chopping block, it is believed, will be things like children's articles, toys, personal care products, and cleaning products. These are rumors. No one will confirm it, but that seems to be where they're focused. And what will happen then is, let's say they choose toys, they will go to the toy industry first and say, you all need to perform an alternative analysis on all of the toys in your products and these chemicals of concern. How would you reduce them, their use in your supply chain? How would you reduce people's exposure to these chemicals? Are they necessary? How could you get out of them, etc.? It's a very short time frame that companies would have in order to do this, and they would be forced to work together in order to have any sort of efficiency on this. But it's expected to be very far-reaching and a heyday for consultants. If you have kids graduating from college in the near future, you might suggest that they go into this field. Once those alternatives analyses are provided to the agency, then it will proceed with a regulatory response based on what they've received with the alternative analyses. And here's the full list. It runs the gamut from they can ask for more analysis. They can require warnings for consumers, some sort of product information to consumers. They can put limits on the levels of these chemicals that might appear in the products. They can ban products that contain these chemicals. They can require engineering controls in the manufacturing process, or they can require a take-back of the products, for instance, at the end of their life, as, for instance, occurs with, say, mercury in certain types of light bulbs. Or they can even ask the industry, require the industry to fund research and development projects related to those products. So at the moment, it's very unclear. It's a framework regulation. It's very unclear what they will do with this, but there is enormous power that now rests with the California Department of Toxic Substances Control once these regulations are implemented. They're going to move down the line from one industry to another. So now I'm going to move on to Rhonda Stewart-Goldstein, who's going to talk about the California unauthorized recording law.
Thank you, Trent. Turning now to the California rules regarding the unauthorized recording of communications, or the California Invasion of Privacy Act. And in California, this law resides in the Penal Code, and in particular, we'll discuss Section 632, which requires that all parties to a confidential communication consent to the recording of the communication. In this respect, California is different from a number of other states, which allow only a single party to the communication to consent to its recording. In California, Section 632 can be enforced criminally and involves criminal penalties. Those penalties include a $2,500 maximum fine for a first violation, as well as up to 1 year imprisonment. For subsequent violations, the fine rises to a maximum of $10,000, as well as up to 1 year imprisonment again. Section 632 also includes a private right of action, under which there is no need for an individual aggrieved under the statute to show any actual damages. It's simply enough that his or her communication was recorded without consent. Under Section 632, there are penalties available to the individual, and those penalties will be the greater of $5,000 or 3 times the amount of actual damages, if any exist. Section 632 is rarely enforced criminally in California. However, it is the subject of numerous consumer class actions, and those class actions typically involve allegations that a consumer or group of consumers called into a business's customer representative line or the like, and their communication and conversation was recorded without their consent. Turning to some of the potential defenses for consumer class action, and we'll discuss 3 here. The first is standing. And standing involves undertaking a factual investigation into the circumstances surrounding an individual plaintiff's call. For example, if you obtain information discovery, such as the plaintiff's phone number, you can do research on your end to try to track and trace the call to determine whether it was in fact recorded as the plaintiff alleges. If the call was recorded and a tape of the recording exists, you can obtain the tape and review it to determine whether it might help you to establish any of the other defenses that we'll discuss. For example, the second defense is confidentiality. Section 632 only reaches confidential communications, and in California, confidentiality is determined by an objective standard, meaning that courts will look to whether the plaintiff had a reasonable expectation that his or her communication would not be overheard or recorded. Some courts have examined the content or the substance of the communication to determine whether a reasonable expectation of confidentiality existed. And some courts have looked at issues such as a mere billing dispute as to be not sufficient evidence of confidentiality. On the other hand, if the plaintiff is calling to discuss his or her sensitive medical or financial information, that can be deemed to have a reasonable expectation of confidentiality. Some courts have disagreed with looking to the content of the communication, and in those instances, you'll want to look to other circumstances that may exist, such as the location from which the plaintiff called. For example, if the plaintiff called from a cell phone in the middle of a crowded public place, then there's an argument that he or she did not have a reasonable expectation that no one would overhear the communication. The final defense we'll discuss is consent, which is a complete defense to the statute. And consent can be obtained from the consumer by simply providing a notification at the outset of the call that the call may be recorded or is being recorded. Once that notification is provided, the consumer has the option to continue the call, thereby consenting, or to simply hang up and decline to continue the conversation. Consent may also be pre-cleared or pre-obtained through documents such as an account agreement that provides that any communications that the consumer may have with the company may be recorded. So what are the takeaway considerations for businesses? First, there's a relatively easy method to comply with the statute, and we've all heard this when we've made our own calls into businesses. It's a message provided at the outset of the conversation, often pre-recorded, that says this call may be recorded for quality assurance purposes or the like. The thing to remember here is that not only must this message be provided when customers make incoming calls to the businesses, but if your telemarketers or customer service representatives are making outgoing calls to consumers that may be recorded, the message will need to be provided as well. And although there's a relatively easy method to comply, it's not always easy to make sure that no mistakes are made. For example, customers calling into a customer service line may receive a prompt that gives them different options to select based on the purpose of their call, such as press 1 for customer service, press 2 for technical support, press 3 to get an automated message check telling them their account balance. If changes are made to those call prompts such that calls are rerouted in a different way, you need to make sure that the messages are routed as well and provided wherever needed. The danger here is that the potential liability can be very large. The statute provides for a penalty of $5,000 per call, and so the charges can add up relatively quickly if you have a high volume call center or are making lots of calls to consumers. So it's important to be diligent and alert your call center staff for the need to provide these messages, particularly if they're not being provided pursuant to a pre-recorded message. Moving along to what we're calling zip codes, and that's a reference to the Song-Beverly Credit Card Act. The Song-Beverly Credit Card Act is a California law that prohibits businesses from requesting and recording a cardholder's personal identification information in connection with a credit card transaction. The Song-Beverly Credit Card Act was intended to address what the legislature saw as the misuse of personal identification information for essentially marketing purposes. Now, under the Act, it was long clear that personal identification information included an address or a telephone number, which are explicitly referenced in the statute. However, it was an open question as to whether personal identification information included a zip code standing alone, which businesses were requesting and recording for purposes such as determining what locations or neighborhoods to send their marketing materials and mail order catalogs to. The California Supreme Court answered this question regarding zip codes in 2011 in a case captioned Pineda versus Williams-Sonoma Stores, Inc., and the site for that is 51 Cal 4th 524. In Pineda, the California Supreme Court held that personal identification information does in fact include a standalone zip code. The court reasoned that the zip code pertains to or regards the cardholder and can be used together with the name to locate a full address. There are numerous exceptions to the Song-Beverly Credit Card Act, and those include if the business collecting the information has a special purpose for collecting it, which is incidental but related to the transaction, such as shipping, delivery, servicing, installation, or for fulfilling special orders. Another exception is where the information is used solely to prevent fraud, theft, or identity theft at a retail gas pump. Furthermore, other exceptions include cash advance transactions and where the business has a legal or contractual obligation to collect and provide the information, such as to a credit card company. The Song-Beverly Credit Card Act can be enforced by either the cardholder or by certain public prosecutors. Where the statute is enforced by public prosecutors, injunctive relief is available where applicable, and they are also entitled to recoup their costs. In all actions, penalties are available. The penalties include $250 for the first violation, as well as $1,000 for each subsequent violation. Businesses can avoid this penalty if they can show that the violation was A, unintentional, and B, the result of a bona fide error made notwithstanding the maintenance of procedures that were reasonably adopted to avoid the error. As a result, businesses should make sure to implement policies and procedures clearly setting out the circumstances under which personal identification information can be obtained, and should make sure to train and alert their sales staff regarding the policies.
So we've received a couple of questions from the chat feature, and I'll read those off, but if you have additional ones, please send them in. And again, each of us is available afterwards, and feel free to follow up with us by email or phone. We'd be happy to talk with you. The first question was for Kelly and has to do with Made in the USA claims, which is how far back do you have to go in the supply chain in terms of the sourcing or origination? If you have a product that uses a frame that was assembled in the USA, the ingredients for the paint used on the frame are traceable to one that was made with a material that was sourced in India, can you still say made in the USA on the product? Kelly?
Thanks, Trent. That's a good question, and the short answer is we don't know for sure. There's very little case law in this area, and therefore making a Made in the USA claim under even these circumstances is risky. And while we'd hope and expect that courts would be reasonable, the Kwikset case really indicates that courts will be pretty literal in reading the statute. So again, we would caution retailers to make any claim like that with extreme care.
We have another question on slack fill for Angel. Has there been an increase in district attorneys' zealous prosecution of violations, or have the prosecutions remained steady? Do you know what industries are being targeted mainly, or how the cases arrive at the DA's offices? Are there complaints, or how do they get there?
I would say that there was an increase, particularly over the past few years when the state was undergoing a budget crisis. And the DAs would deny this, but the revenues from these cases go directly to the district attorney's offices, which were, for the last several years, underfunded. Now the state now has a surplus because taxes have increased. So I don't know if that means there's going to be a corresponding decline. And when we talk about prosecutions, what we're really talking about is the threat of civil action, although there is a misdemeanor provision in the slack fill statutes, is the threat, and those cases generally result in settlements. I personally know there have been a number of additional cases recently. I don't list them there because some of them are our clients, and we don't necessarily like to advertise those. But in terms of industries that are being targeted, candy has been a frequent target. So-called theater boxes with candy, the box, and then you shake it, and it's got a lot of candy in it. It's only partially full. Personal care products, makeup, mascara, things like that. Variety of other products, over-the-counter supplements and medicinal aids, particularly that come in small bottles and are packed in larger boxes, mostly to prevent pilfering. But, as I said, the DAs don't always accept that argument. So I think there was an increase. Maybe we'll see it decline somewhat, but you really need to be on the lookout.
We have another question on Made in the USA for Kelly. Would you recommend spelling out the percentage of component parts that are used in the product so that you can make a qualified claim about Made in the USA on your product when it's sold in California?
Well, Trent, this is one way to get around or to make that Made in the USA claim, but if you are spelling out the percentage of component parts, you want to absolutely make sure that that percentage is completely accurate, again, to make sure that you're falling in line with the requirements under California's law.
There's another question here about retention procedures for recorded telephone calls. That's sort of outside the scope of what we've talked about before. But when we have litigated these cases, it has often been useful if there is a tape recording of the call of the person who is the lead plaintiff in the case. And mostly because it allows us to sometimes identify whether the caller really intended for the call to be private. We've had situations where you can hear background noise, you can tell that they're in a Starbucks, they're talking to other people that are interrupting them while they're on some long customer service call, that sort of thing. And there's some settlement value in having that. But the retention procedures are really related much more to things like the statute of limitations for certain claims or other retention policies within your business. Thank you, everybody. We're at the hour now. We've really appreciated the opportunity to share with you some of what we've learned in working with companies that do business in California. Again, feel free to follow up with any of us on any of these or other issues overall, I would say it's very important to be careful out there. This concludes our program. Thanks very much.
And this is recognizing that the case law in the area is not particularly robust in California. There's an argument that you could make that there's no standing to sue. Under this argument, a plaintiff may simply fail to allege standing or may be unable to establish it. However, standing has gotten a little bit easier for plaintiffs to meet under the unfair competition law for product misrepresentation cases. So even if there is standing to sue, because in California, the monetary relief available is restitution, you can argue that there is no monetary relief available. Restitution is the difference in value between what the plaintiff gave the defendant and what the plaintiff received. And plaintiffs in this case would have to quantify the amount of the purchase price attributable to a Made in the USA representation. This has been difficult for plaintiffs to do as to date. And finally, these claims are often brought as class actions. Depending on the allegations of the complaint, there are often a whole host of issues to target that would make individual issues predominate over common issues. One such issue, again, is listed on our slide, and it's whether and by how much a Made in the USA representation actually influenced each individual consumer's purchasing decision. So the main things to remember about Made in the USA is that California's rule is different from the rule of the FTC, and it's more strictly interpreted. So in the California Senate Judiciary Committee, following significant opposition from consumer groups. So what's a seller to do if they sell things in California? On the next slide, we talk about compliance issues. If any of your products may touch California, and really for most national retailers, this is virtually guaranteed, you want to make any Made in the USA claim with extreme care. We suggest possibly trying an alternate claim, something that's closer to a qualified claim under the FTC guidelines. We've listed some up on the screen. Made in the USA of primarily domestic components, Made in the USA partially assembled in whatever foreign country it's assembled in, or assembled in the USA from primarily domestic components. This gives you protection, but allows you to still make the Made in the USA claim. And really, you should check with your marketing people and ask them if the Made in the USA claim really matters. And really ask the marketing people and ask them how much that claim matters. Because if it doesn't matter, or the influence of the Made in the USA claim is negligible, you should consider not making the claim in California because it's probably not worth the potential liability to make an unqualified claim. Now, on the next slide, we talk about what to do if you do get sued. There are a few potential arguments in defending against a Made in the USA lawsuit. Now, in California, the courts have taken a very strict construction of this statute. We've listed an example from Kwikset up on the webinar, and in Kwikset, the manufacturer made lock sets, and these lock sets were assembled from all domestic components except for just a few pins and screws that were made in Taiwan. These lock sets couldn't be labeled Made in the USA without violating the statute. Now, this is in conflict, California's law is in conflict with the FTC standard. And the FTC standard is not lenient by any means, but for an unqualified Made in the USA representation, the FTC allows for virtually all of the product to be made in the United States. And under the FTC standard, a label Made in the USA can be used if there is no or negligible foreign content. The FTC also has a qualified representation, and that's appropriate for products that include United States content and processing, but just not enough to make that unqualified claim. For a qualified claim, the product should still have a significant amount of U.S. content and processing. And the difference between the FTC and the California guidelines hasn't gone unnoticed in California. Just last year, the California Assembly passed a bill to try to amend the California statutes to conform to the FTC standards with respect to Made in the USA. However, that bill was defeated.
From Arnold and Porter.
Good morning, everyone. This is Seller Beware, Avoiding the Pitfalls of Selling to California Consumers. And this is the second of two sessions, which we've titled The Grab Bag of Pitfalls. This will be something of a speed round, a tour through some of the more treacherous parts of California law for those who make or sell products that are offered for sale in California. For today's webinar, the lines have been muted, but if you need assistance during the conference, press the star key and then 0 on your phone, and a conference coordinator will be there to assist you. I have sent out a chat to everyone who's on the line now. Please use the chat feature tool within WebEx to ask questions throughout the program. We might not be able to get through all the questions, we just have an hour today, but don't hesitate to contact one of us directly following the event. We'd be happy to follow up with you as well. You can send your chat questions, we'll collect them and probably address them at the end of the session. This event is being recorded and it will be posted on the Arnold and Porter website where it will be available to the public. For your convenience, shortly after the program, we will send a link with a short evaluation and the presentation materials to each of you. Those of you, I believe, in New York and New Jersey will also receive a quiz, which is a required part of your continuing legal education requirements. So today's program is looking at some of the ways in which it is difficult to do business in California. We collected these from questions and issues that all of our clients have encountered over many years. We have 4 presenters today, so the presenters are in order: Kelly Welchens, Angel Garganta, myself, and Rhonda Stewart-Goldstein. We're going to begin with Kelly, who is broadcasting from our Los Angeles office on the Made in USA claims. Here's the agenda displayed right now, and then Kelly will begin on Made in the USA. Kelly?
Thanks, Trent. Now, in California, Made in the USA claims are governed by Business and Professions Code, Section 17533.7. The statute is pretty straightforward. It says that any Made in the USA, Made in America, and similar words can't be used on a product or its container when any article, unit, or part of the product has been entirely or substantially made, manufactured, or produced outside the United States.